Equality, and when I refer to equality, I'm referring to the lack of mutuality in the appointment process. Any unfair advantage that any party has at the stage of appointment will result in a violation of Section 18. Let me give an example. There could be so many scenarios where the panel is perfectly eligible, but the party nominating the panel may fill the panel with arbitrators who have already decided a similar issue in their favor in the past. So, in such a scenario, my lords, there is no 5th schedule or 7th schedule violation, but there will still be a violation of right under Section 18, because why should one party have the right to fill the panel with people of their choice?
In fact, you're right. I asked a question in the morning. Are there any apprehensions or objections independent of the 7th schedule? And this is what you are saying, that you appoint.
And I can give a real life example. We did multiple arbitrations in relation to metro rail construction. There was one exclusion clause which was the subject matter of litigation in most of these arbitrations. Now, the first set, we had a completely independent panel. The second set of panels that were given to us comprised of only those who had interpreted that clause in favor of the Metro Rail Corporation. Now, today, if the Metro Rail Corporation has this unilateral power, it's independent of 5th schedule, independent of 7th schedule, but is it not a violation of equality under Section 18, I ask myself. This is the first point. Second, my lords, to answer a query that fell from your lordships is that this Section 18 is located under Chapter 5, which deals with conduct of the arbitration.
But does that not go to the panel as opposed to, the power?
Sorry, my lords?
Does your argument not therefore impeach the panel as opposed to the power to...
My lords, the panel is perfectly eligible because there is no question of subject matter. There is no entry relating to subject matter bias in 5th schedule and 7th schedule.
Well, really speaking, it doesn't encroach, does not breach any provision of the statute.
It doesn't breach any provision of the statute, but the panel comprises of only those arbitrators who have decided the very same issue in favor of the party appointing the panel. That's the reason why, my lords, even though party autonomy is important, party autonomy has to be balanced with... Sorry, my lords?
As against each of the arbitrator who had decided similar cases against
they have only decided one such case, but that's enough. They have not decided more than 2, so therefore 5th schedule will not come in. So today there is no grievance against the individual arbitrators, but it is that party that has filled the panel with persons who have already decided the issue in the past. A party should not be permitted to weaponize the appointment process.
Party autonomy cannot be for one of the party, but party autonomy has to be mutual for both the parties.
And I go down, my lords, and party autonomy has its limits. If there is a mandatory provision of law, such as Section 18, party autonomy would give in to such a mandatory provision, because having a blemishless process is an equally, if not more important consideration. Today, your lordships has laid down the law in relation to minimum judicial interference. Why? Because it presumes that the regime is blemishless today, because of the 5th schedule, because of the 7th schedule.
Blemish. In TRF, they mentioned that we are not concerned about respectively, right? So, persons who have decided on a particular aspect in favor of the organization may be more respectable.
I go back to what my learned friend argued on the incentives for appointment. Yes, my lords. Then, my lords, before I conclude, my lords, there is one passage, I don't think I'll have the time, but I'll only provide the reference to the drafting history. Some portions of the drafting history my learned senior read out, but at page 9823, volume 4, tab 135.
But your point that, look, suppose they constitute a panel, and that panel only consists of people who have arbitrated in the past and say decided that issue, construction of a specific notice provision for termination. favorably to that particular employer, can you not raise a ground of challenge under 12A?
No, not because it's not any of the grounds contained under Schedule 5 or 7.
No, but 12A doesn't confine you to only the 5th or the 7th schedule. The 7th schedule. 12 says, such as the existence, either direct or indirect, of any past or present relationship with, or interest in any of the parties, or in relation to the subject matter in the disputes, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. So suppose a railways or any PSU appoints an arbitrator who has decided that very issue. All the arbitrators in the panel are people who have decided in their favor.
May I, the two aspects.
This not be a ground.
First, I will never know as a contractor because what needs to be disclosed would only be what is set out in the 5th schedule. So if this is not covered on the 5th schedule, so I will never know whether they have decided in the past or not. Point number one. Point number two, let us assume that they have decided the same issue, not in relation to the same Metro Rail Corporation, but in relation to another public sector undertaking. Your Lordship sees exclusion clauses in so many cases, so many government contracts.
You have decided the same interpretation.
Same interpretation. So why should one party have the benefit of picking?
There is an asymmetry of information according to you, because the contractor will not know everything about that arbitrator.
I bow down, my lord.
Or each of the arbitrators.
And my lords,
identifying the background, you'll have to engage a detective agency to find out the background of the arbitrators.
my Senate senior also mentions that HRD Gale.
Same ground was rejected.
Where?
HRD versus Gale, the arbitrator had given a similar award earlier.
That was rejected.
Yes. So, my lord, the problem here is the process and not the individual, my lord,
Yes,
arbitrator.
sir.
That's the real problem.
My lords, then, my lords, on the issue of whether, even though it is located in Chapter 5, whether Section 18 will apply to the arbitral appointments, my lords, there is one reference I would like to provide your lordships. At page 9823, Volume 4, tab 135, which is part of the drafting history of the UNCITRAL model law. My learned senior read out certain portions. This portion also deals with it and specifically says that it will apply to the agreements between parties in relation to the procedure for the arbitration. And even when your lordship sees the scheme, even though it says conduct of arbitration, 18, 19 and 20 are prior to the notice of arbitration. 19.2 gives parties to agree upon the liberty in relation to the procedure. 21 gives parties a liberty to agree upon the place of arbitration. Therefore, when you look at the scheme, even though Chapter 5 deals with conduct, it begins with the agreement between parties on various aspects before going into 21, which is the commencement of the arbitration, and thereafter the procedures like pleadings, etc. in the arbitration. Therefore, my lord, the reading of the scheme, along with the drafting history in my respectful submission, would in my respectful submission make it clear that Section 18 applies to the appointment process as well. This passage, my lords, is very, very clear. The passage that I just mentioned, I've referred to it in my note, my lords. I don't want to read it out because of the paucity of time. Finally, my lord, just one, before, if your lordships is to accept this contention that Section 18 applies, there are various issues that will arise. What happens to arbitrations that have been concluded? What happens to arbitrations where the challenge is pending? Because Section 18 was unamended, it will apply even in the pre-2015 era. Therefore, your lordships may consider using the power under Article 142 to restrict the applicability in a post-2015 scenario where a challenge has been raised and is pending before a court today. Because if it is going to apply across the board, it will second consequence. What happens if the offending portion alone is severed? Can the doctrine of severability and blue pencil rule be adopted, and can the court then go ahead and appoint an independent arbitrator? In this regard, my lords, if one party has provided consent on the basis that it has a right to unilaterally appoint or appoint a panel, that goes to the root of the consent to arbitrate. Therefore, in my respectful submission, the doctrine of severability and blue pencil rule cannot be read in because it vitiates consent in the first place. So if your lordship is to accept the Section 18 argument, the arbitration clause itself goes. Point number 2. Point number 3, who can raise it? Can today the party that has nominated the panel and thereafter lost in the arbitration, go and challenge it saying section 18 has been violated. In my respectful submission, that the answer would be no, because in such a scenario, the right under section 18 itself would not kick in. Section 18 is a right that accrues for the benefit of the party that is discriminated against. Deeply obliged, Malala. There are a lot of foreign judgments and articles that I've referred to in my note. I don't want to go into all of them. Deeply obliged.